Karena ibu jam 10 international conference siya yang melaan posi dulu wala on time kan.
Lebih lalu sampai lah membantu rambut.
Your morning eyes, I could stare like watching stars. I could walk you by and I'll tell without a thought.
Hello, good morning, Dr. Rawin. Are you here?
Yes, good morning.
Okay, good morning, sir. So, how are you today? How are you
Yes,
today, sir?
I'm great, and I'm very honored, to be invited to present my, lecture today. It's very great
Okay,
to
thank
see
you.
all of you.
Okay, all right. Before that, I'm going to opening this meeting before us. Okay, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning, international short course participants, and good morning, our special speaker today, Dr. Rawin Lila Patana. Hello, Dr. Rawin Lila Patana. How are you?
Great. Good morning as well, and greetings from Bangkok, Thailand.
Okay, thank you. First of all, I would like to thank to Allah Subhanahu wa Ta'ala who has given us blessings and mercies so we can gather at this online meeting in a good condition. Don't forget to offer our prayers and blessing to our great prophet Nabiullah Muhammad Sallallahu Alaihi Wasallam, as well as to his noble family and his friends. Respectable the speaker at the International Short Course event this morning, Dr. Rawin Lila Patana from Chulalongkorn University, Thailand. The Honorable all lecturers of the Faculty of Law Universitas Muhammadiyah Surakarta and the Honorable all the participants of the International Short Course event this morning. Ladies and gentlemen, I would like to introduce myself first. I am Ellen Justin Binandito, law student of Universitas Muhammadiyah Surakarta. I'm as moderator of the International Short Course in this morning session. I'm honored to have the opportunity to accompany all of you at a wonderful event this morning. For your information, this morning International Short Course will discuss about the erosion of rule of law in declining democracies, which will be delivered by our best speaker, Dr. Rawindila Patana. Ladies and gentlemen, allow me to introduce a little about our amazing speaker this morning. Our speaker today is Dr. Rawindila Patana. He is a PhD graduate in Law University of Bristol, United Kingdom, 2014 until 2019. Then he continued his studies as a Master of Law, LLM, University of Bristol, United Kingdom, 2011. Then he also took certification as Thailand's lawyer license, the Lawyer Council of Thailand, 2008. Then Bachelor of Laws, LLB, First Class Honors, Chulalongkorn University, 2008. And then Dr. Rawindila Patana also has work experience as Assistant Professor A4, Faculty of Law, Chulalongkorn University 2022 until present, and also as a lecturer A5, Faculty of Law, Chulalongkorn University 2009 until 2022. He also published many interesting research journals that can be studied. Next, I will read our agenda this morning. First agenda, the speaker will deliver material on a previously prepared topic for approximately 1.5 hours starting from 10 a.m. until the end. Then the second agenda is a question and answer session with the remaining time until 12 p.m., which will be guided by the moderator and the speaker will answer. And the last agenda is closing. Before our main event begins, I remind the participants again that our agenda this morning has several important regulations which are still the same as the regulation present at the previous meeting. Now, let me welcome our amazing speaker this morning, Dr. Rawindila Patana, to present material about the erosion of rule of law in declining democracies. Dr. Rawindila Patana, your time and screen are yours.
Thank you very much. And once again, good morning to all of esteemed and distinguished audience. And I'm very pleased and honored to be invited to deliver a lecture today. Yeah. Can you see my PowerPoint presentation?
Yes, sir. Yes, sir.
Can you see my yes, okay. Thank you very much. So Yeah, the topic that I'm assigned to speak today is concerned with the erosion of the rule of law in declining democracies. And at first when I received an email from UMS, when I read the topic, I felt that wow, the topic is very interesting, but at the same time I also felt that the topic is pretty challenging as well, because first, as we know, nowadays, the study of rule of law, has gained global attention. Actually, if we Google, the word rule of law, we can find a lot of books and articles on this topic, written by many scholars, and actually, I would say that in the past, 3 years, the UNSW, the University of New South Wales, led by Professor Gabriel Appleby, she just initiate a book series on the rule of law, and actually several books in this series have already been published, including those on the rule of law in Germany, Brazil, Russia, and the United States. And next year, I'm going to publish my monograph on the rule of law in Thailand as well. So I mean, this book series, provides, a testament to the fact that, the study of the rule of law, has gained attention globally. But at the same time, we have to, I would say that we need to admit that nowadays, we have witnessed, a decline in the rule of law in many countries, especially in Asia. So as a scholar from Southeast Asian country, I would say that it is, I mean, this short course provides a great opportunity for me to share my perspective and my idea towards how the rule of law has been challenged, especially in the Southeast Asian context. So this is how I'm going to present my lecture today. So first, I'm going to provide some general features and assumptions underlying the rule of law. So I'm going to speak about the standard conception of the standard concept of the rule of law, and then in the second part of the lecture, I'm going to examine whether the Southeast Asian context should be seen as an example of the rule of law's erosion. I mean, for some people, we might think that, well, rule of law in Southeast Asia is not that good. But actually, I would say that we should not regard, the development of the rule of law in our, region in a negative way. Instead, we should be more realistic that, of course, on the one hand, we can witness, the rule of law erosion in our region, but at the same time, we can also see some, we can also detect, some, good prospect of the rule of law development in Southeast Asia as well. Okay, so let's start with the first issue. The general feature of the standard concept of the rule of law. I would like to start from the first bullet point that I put at the top. Here I put that, well, the rule of law is a global concept, but at the same time, as Professor Jeremy Waldron states, this concept is also an essentially contest concept. But what does this statement mean? Well, I would say that at first, if we look at this statement, it is true that that nowadays the rule of law has become a global concept, right? If we look at the international human rights treaties, we can see that these treaties try to promote the idea of the rule of law and human rights. They normally say that, well, if any country, any state want to be regarded as as a good as advocates of human rights, those countries have to respect the rule of law. And and we can also see that the international community has generally apply the rule of law as a benchmark for determining good governance. So this means that if the government wants to be regarded as developed countries, as well as good members of the international society, that government is expected to respect the principle of legality, as well as democratic values, in particular the ideas of tolerance, broad-mindedness, as well as the protection of human rights, right? But at the same time, if we read through the text of international human rights treaties, I would say that you cannot find an exact or specific definition of the rule of law. In other words, no agreed definition of the rule of law is provided in the international human rights treaties. And we can also see that across the globe, if we look throughout the world, no agreed definition of the rule of law still remains. And in fact, if you look at this sentence, in fact, we can identify three types of disagreements throughout the world. First, we can see that different jurisdictions tend to adopt different conceptions of the rule of law, right? And secondly, we can also see that different scholars and philosophers define the rule of law differently. And thirdly, we can see that in some, I would call those situations, in some hard cases or controversial cases, different scholars may propose different ways to implement the rule of law. So let's start with the first type of disagreement. Different jurisdictions adopt different conceptions of the rule of law. And by this term, I want to say that the ways that the rule of law is implemented differs across jurisdictions. So in this regard, I'm going to use the case of what scholars normally call the English rule of law and the German concept of Rechtsstaat as examples. So let's start with the English rule of law. Normally, if we want to understand, the general features of the English rule of law, scholars tend to suggest that, well, you need to start, by reading, monograph written by a very famous professor, Professor Albert Dicey, a gentleman in the picture. Albert Dicey was a professor at Oxford University back in the 19th century, and he wrote a very famous book on constitutional law, and that book provides a kind of a backbone for understanding the English rule of law. And according to Dicey, the English rule of law contains three key elements. So let's start with the first element. Well, the first element is concerned with the idea of the law-based government. It says that, well, the rule of law centers on the idea of government authority based on law. So this means that the absence of legal authority is considered or regarded as a kind of an abuse of power. So this means that if the government want to exercise its power in such a way that or to restrict rights or liberties of individuals, the government has to do that on the basis of law, or else that actions will be considered illegal, right? So this is the first element of the English rule of law, the government based on law. Now let's us turn to the second element. The second element says that every man, whatever be his rank or condition, is subject to the ordinary law of the realm and amendable to the jurisdiction of the ordinary tribunal. What does this mean? It seems that these sentences are pretty complex, right? But if we read Dicey's writing carefully, we can see that in his view, no one, including the government itself, is above the law. So it means that everyone is under the law, right? Everyone is equal under the law, and instead, everyone, must be treated equally under the law. So this is the key idea of the second element of the law. But at the same time, I mean, if you read monograph or books or articles that try to analyze Dicey's writing, many scholars tend to interpret the second element of the law to mean that Dicey did not really prefer the establishment of a special court, because in Dicey's view, he tended to think that a special court, like the administrative court, serve as a kind of a court for the privileged groups. In other words, if in Dicey's view, if the administrative court is established, it tends to serve as the court that allows officials to be put in a special position. So that is why nowadays, if you go to the UK, there is no special courts. There is no special courts like the constitutional court or the administrative court. Now let us turn to the third element. Well, as we know, in the United Kingdom, unlike Indonesia or Thailand, the UK doesn't have a written or codified constitution like our countries, right? But instead, it has, I mean, its constitutional law comprises a number of acts of parliaments as well as the court's decisions, right? And in Dicey's view, he tended to think that as the UK doesn't have a codified constitution, the individual rights are best protected by common law. So this means that in his view, Dicey tend to entrust the court, the judiciary, with the primary role in protecting human rights and individual liberties. So this is the third element of the English rule of law. Now let us turn to the German concept of the rule of law, or Rechtsstaat. Well, we can see that the German concept of Rechtsstaat tends to share several ideas with the English rule of law, but at the same time, there are also some differences as well. Well, we can see that the two concepts, both the English and the German conceptions of the rule of law, both tend to emphasize the idea of law-based authority. So under the German Rechtsstaat, the state cannot exist without being grounded in law. And of course, the state and its action are also limited by law. So we can see the similarities between the two conceptions, right? But at the same time, we can, as I just point out, there are also some differences between the German and the English conceptions of law, because in Germany there is a written constitution, while in the UK there is no written constitution, right? So in contrast with the English rule of law, the German Rechtsstaat emphasizes the idea of constitutional supremacy. But the thing is that if you want to actualize this idea, the idea of constitutional supremacy, you need to establish special organs or special institutions that function to ensure that that the constitution is actually and practically the supreme law of the land. So this idea, the idea of German Rechtsstaat, then emphasizes and supports the idea of the establishment of a special court, especially the constitutional court and the administrative court, in order to review laws that are accused of contravening the constitution. As I just point out before, in the UK, there is no special court like the constitutional court or the administrative court. But in Germany, the concept of Rechtsstaat tends to favor the establishment of special courts functioning to review law in order to prevent those laws from contradicting the wording of the constitution, right? So this is the German concept of Rechtsstaat. But apart from the fact that different jurisdictions adopt different conceptions of the rule of law, we can also see that different scholars and philosophers appear to define the term the rule of law differently. Well, if we Google the two words, the procedural conception of the rule of law and the substantive conception of the rule of law, once you do this, you can find a lot of, results, because even nowadays, scholars tend to define, the scope of the term differently. Some scholars tend to, focus on the procedural aspect of the rule of law. And under this idea, the procedural conception of the rule of law, the authority of the law stems from the validity of procedures by which it is adopted. So we can see that this idea, tends to focus on how law is made and how law can be, followable by citizens, right? And in fact, a famous theory proposed by Professor Lon Fuller, the internal morality of law, tend to serve as a good example of this procedural conception of the rule of law. I'm sure that all of you already know Professor Fuller, right? Professor Lon Fuller, he wrote a very famous book, The Morality of Law, and in that book, he proposed the concept called the inner or internal morality of law. And his idea is that law, we should not see law simply in terms of a mechanism or an instrument of the state to impose its power on individuals. Instead, Fuller tends to see that there are some procedural values that law needs to adopt. And Fuller proposed 8 principles that lay the groundwork for a legal system. And of course, in his view, for a legal system to count as a legal system, it needs to comply with these eight principles. And each of these principles emphasizes not the content of the law, but the manner in which they should be created. For instance, he says that a good legal system must respect the principle of non-lethal activity. The reason is that if the government is able to pass law that apply retroactively, people cannot predict what they have to do, and this eventually undermine the concept of legal certainty within the that constitutional system, right? But how about the substantive conception of the rule of law? Well, scholars tend to define substantive rule of law or substantive conception of the rule of law as as the conception of the rule of law that also emphasizes, some substantive value. So this means that good laws, must also embrace, several substantive value. For instance, the protection of human rights. Law cannot just be seen as, as something that are passed through good, through good lawmaking procedures. Instead, they have to, comply with substantive values, especially, human rights protection. And this idea is proposed by a famous English jurist, Lord Bingham. Now let's turn to the third type of difference. Can also see that some scholars tend to disagree on how the rule of law should be implemented, especially during especially in what I call hard cases, in some controversial cases. In this presentation, I would like to use the debate between two famous professors, Professor Hart and Professor Fuller again, And as we know, Professor Hart and Professor Fuller, they differ on how, unjust laws, especially, Nazi law should be approached in relation to the rule of law. Actually, the debate between Fuller and Hart, took place back in the 1950s. And, at the time, as we know, it was, just a few years after the Second World War, right? And during the World War, as we know, the world witnessed, autocracy caused by the Nazi regime, right? During the Nazi regime, Hitler, passed a number of unjust law, including law that that punish people only because they insult, the leader, that is, Hitler himself. So after the war, the international community had to do something, had to implement measures, to deal with those unjust law. And the thing is that, Hart and Fuller, they tend to, they disagree on how to deal with those unjust laws. Actually, there are two questions that are related to their debate. The first question, we can say that that Hart and Fuller, they differ on whether unjust law should be denied their status as laws. I mean, if you ask Professor Fuller, he would say that, well, unjust law is not law at all. But if you ask Professor Hart, he would say that, well, so this turn to the second question, Hart tend to think that, if we, in order to deal with unjust law, it's better to address the problem, through legal procedures themselves. In other words, Hart admit that, well, unjust law are law, but this doesn't mean that he's encourage us to respect or to comply with those laws. Instead, he sought to deal with unjust law through legal procedures. So here, we can see, big difference between Professor Fuller and Professor Hart, when they approach, how unjust law should be dealt with in relation to the rule of law. But anyway, despite the differences already mentioned, we can still identify several shared theses in the different conception of the rule of law. And in this presentation, I would like to propose 3 theses that underlie or underpin the standard concept of the rule of law. I call the first thesis the modernity thesis. The second one, I call it the self-determination thesis, and the last one is the legality thesis. So let's start with the first thesis, the modernity thesis. Well, this thesis suggests that the basis of legitimacy of the modern rule of law is no longer based on the traditional authority, that is, the sacredness of the past. So the modern rule of law tends to think that, well, the basis of legitimacy of today's, administration is not a kind of, spatial power from the sky, from the celestial domain. No, they tend to think that modern state needs to adopt, modern legal system, and the modern legal system should be a man-made legal system, and there should be, the establishment of a modern bureaucracy. And this idea also supports, the process of democratization as well. So this is the modernity thesis. How about the second one, the self-determination thesis? According to this thesis, the rule of law, the rule of law, the standard rule of law, tends to perceive, individuals as, as I put it here, as equal rational beings who are good in themselves and who can determine what are best for themselves. So the protection of individual rights is the norm under the rule of law, and their restriction is considered the exception. Now let us turn to the third thesis, the legality thesis. Well, the legality thesis, rests on the idea that the authority of the state must derive from law. In other words, it emphasizes the idea of a law-based state. The legality thesis also asserts that the state must restrict, the protection. The state may restrict, the protection of rights. I think this is normal because, if we look at, constitutions, across the globe, we can see that most of the constitutions in the world, actually, I would say that every constitution in the world, allows, the state, to impose measures that lead to the restriction of individual rights and constitutional rights, right? But the rule of laws, the concept, the standard concept of the rule of law says that, well, if the state want to do this, it has to comply with some parameters, especially, the principle of proportionality. So this means that, if the state want to impose measures that lead to the restriction of rights, it has to adopt measures that cause, I would say that doing so, requires a kind of, legal basis and must be done through, the least restrictive means. And the rule of law, further stresses that legal safeguards, and remedies against abuse of power must be built or put in place in advance in order to ensure that no abuse of power happens. So this is the legality thesis. Okay, so we can see the three theses underlying the rule of law, right? The modernity thesis, which says that the basis of legitimacy for the modern rule of law is no longer based on the traditional authority. The second one is the self-determination thesis, which regards, individuals as rational beings, and the restriction of their rights, must be done on the basis of law, and the state, must avoid, restricting individual rights. And the legality thesis says that, well, if the state wants to impose, measures that aim at restricting individual rights, it has to adopt the measures that causes, the least restrictive effect on those rights, right? But now, let's us turn to Southeast Asia. Let's us turn to the Southeast Asian context. I would say that like many countries in the world, Southeast Asian countries, cannot avoid the process of globalization, modernization, and of course, democratization. So this means that these countries, cannot totally resist, the rhetoric of the rule of law. This is quite interesting, because if you read through the text of the constitutions of some, even some socialist countries like Vietnam or Laos, I mean, those countries also adopt, some core ideas of the rule of law. For instance, the ideas of human rights. You can see that, the current Vietnamese constitution of 2013, contains, provisions on human rights. In Laos as well, back in 2005, if I remember correctly, and actually it is the current constitution of Laos, the current constitution of Laos, also contains, provisions on human rights protections as well. But because, this lecture, our focus is on countries that are, democratic countries, right? So my focus will be on, three main countries, Malaysia, Indonesia, and Thailand, okay? But anyway, well, we need to accept that, that I just point out, that the rhetoric of the rule of law,
Bahasa Inggris cok ora mudeng cok.
cannot be resisted in these countries nowadays. But, despite the processes of globalization, modernization, and democratization, we need to admit that the law is not an indigenous and dominant concept in Southeast Asian countries. This is quite obvious, because, like, for instance, in Thailand, in my country, as we know, Thailand has the monarchy, right? And actually, the traditional source of legitimacy in Thailand is not the rule of law, but is the power of the king. And even nowadays, there's still a lot of people who tends to believe that the true power, or the true power of the country, or the core basis for state power in Thailand, for some people, they still think that that thing, still derived from the king. Or in Malaysia as well, and in Indonesia, you also got the idea of Pancasila, right? Which constitutes, the core idea of the state as well, right? Yeah, but yeah, and also, in recent years, can also see that, several formerly democratic Southeast Asian countries, have witnessed kind of, nationalist conservative movements that challenge the rule of law. So let's start first with the case of Malaysia. Well, let's consider first the case of Malaysia. The current constitution of Malaysia, the 1957 constitution, establishes, a democratic structure. So yeah, I mean, if we read through the text of the Malaysian constitution, you can see that, well, the country, I mean, the constitutional system of Malaysia tends to be quite similar to the Westminster system in the United Kingdom. We can also see that in recent years, some of the Malaysian judges also advocate the idea that that the separation of powers, judicial independence, which are, of course, the core ideas of the rule of law, are the basic structure of the Malaysia constitutional system as well. But again, if we reread, especially section 153 of the Malaysian Constitution, we can see that the Malaysian Constitution also enshrines the conception of Bhumiputra, right? And this idea, as we know, emphasizes the protection of special rights and privileges of the Malays who are deemed to be, the son of the land, the son of the soil. So the Malays are considered as Bhumiputra, and the Chinese are considered as non-Bhumiputra, right? And the thing is that in back in 2018, the Malaysian government, DPH at the time, planned to ratify, the ICERD, the International Convention on the Elimination of All Forms of Racial Discrimination. But the thing is that the ratification, if that convention will ratify it, that ratification would have promoted the rule of law environment, right? Because the convention seeks to promote the concept of equality, which is called another concept, another core idea of the rule of law. But anyway, the government's plan, was at the time, was strongly opposed by many segments of civil society, because those segments of civil society, they tend to think that the ratification would undermine the protection of Bhumiputra. So the Malaysian case provides as an example that even a country with quite a solid democratic structure also witnesses movements that I would say that are skeptical about some elements of the rule of law. How about Indonesia? I think Indonesia case is very interesting because I would say that Indonesia should be regarded as the the beacon of democracy of Southeast Asia. And of course, I think Indonesia is the most stable democratic country in Southeast Asia, right? And yeah, and I'm sure that all of you know better than me. After Indonesia before 1999, the country had witnessed decades of authoritarian rule. But between 1999 and 2002, right? Your country underwent the process of constitutional reform, which led to the idea of a rule of law based state being adopted in the Constitution, Article 1, right? What do you call that? Negula hukum, right? I'm not sure about that. Yeah, if I remember correctly, you can correct me if I'm wrong. But couple months ago, I had a very good opportunity to read an article written by my good friend Mr. Abdul Rahman Satro, and another one written by Professor Simon Butt from Melbourne University. The two papers focus on the attempt to propose the Fifth Amendment to the Constitution, which sought to restore the original version of the current Constitution, the 1945 Constitution. And if I understand correctly, this proposal tends to things that the four amendments that were made between 1999 and 2002 appear to contradict the notion of integralism, and doesn't really fit the concept of culture of Indonesia. So those people including some military figures they want, the government at the time, to restore, the original version of the 1945 Constitution, which centers on the notion of integralism. But the thing that I can find from that article is that, is that even in a very democratic country like Indonesia, there are still, those who think that liberal democratic values, including the rule of law, do not really align with its constitutional culture. So yeah, so I would say that Indonesian case, provides a very interesting example as well. And how about my country? Well, Thailand is is like, another. I would say that Thailand, provides, kind of, or exemplifies, the problem of democratic declines, in Southeast Asia. Actually, back in 1997, some scholars tend to see Thailand as a beacon of democracy in Southeast Asia. But since 2006, the country has witnessed democratic regression. And of course, the country, Thailand, is notorious for the recurrence of military coups. And in fact, we have witnessed more than 10 coups in the past 90 years. So it means that the country has a lot of military coups. But the thing is that, okay, so people might think that, well, Thailand has so many coups, like, but the thing is that, since the 1960s, military coups in Thailand, have never led to kind of permanent dictatorship. Instead, coups in Thailand will normally follow by the creation of a new constitution, which restore the semblance of electoral politics with the Bill of Rights adopted. So that is why coup makers in Thailand, they tend to proclaim themselves as democratic coup makers. So this is quite peculiar, and in fact, back in 2007, it was the military junta itself, that introduced the idea of the rule of law to the constitution, to the coup initiate 2007 constitution. So I would say that the Thai case tends to reflect a situation in which the rule of law is more extensively institutionalized, while also being undermined at the same time. Yeah, but I don't want to say that, well, military coups can improve democracy. Not at all. Instead, if we look at the main objective behind military coups in Thailand, the Thai junta tend to impose the coup to reinforce the idea called Thainess, known as Thainess, or what is being Thai. And to understand Thainess, you can compare Thainess with Panchasila, because I mean both ideas, both ideologies, rest on, I would say, some kind of similar basis. Thainess, emphasizes, the three sacred pillars: nation, religion, and monarchy. So it says that, well, it considers, the Thai monarchy as the embodiment of the nation. So this idea, appears to prioritize the political preeminence of the monarchy. It also emphasizes royal sacredness and inviolability, with the king, seen as the ultimate source of political legitimacy. And, military coups in Thailand, apart from reinforcing Thainess, also aim at eliminating threats to Thainess as well. And those things that are normally considered as threats to Thainess are rising demands for democracy. And the recent military coup back in 2014 will aim towards consolidating, the hegemony of Thailand, because at the time and even now today, Thailand, has witnessed, the rise of anti-establishment movements, anti-monarchy movements. So the loyalist conservative force, including the military, they tend to they incline to, they prefer to adopt, a more draconian measures, to deal with these movements, which eventually led to the imposition of, the military coup in 2014. But apart from the recurrence of military coups in Thailand, the challenge to the development of the rule of law in Thailand is also posed by the Constitutional Court itself. This is quite peculiar, when one says that, well, the Constitutional Court, can pose, threat to the rule of law and democracy, because, if we look at the original theory of constitutional review proposed by Professor Hans Kelsen, says that the Constitutional Court should be regarded as the guardian of the Constitution, right? And in the West, the Constitutional Court, tends to function as the, as the bastion or the stronghold of democracy. It plays, the leading role in ensuring that the countries, remains, democratic. But the problem in Thailand is that, since 2006, since 2006, most of Thai Constitutional Court judges were appointed by the junta. So that is why some scholars, tend to think that, well, the Thai Constitutional Court, serves as a kind of an enemy to democracy and the rule of law. But my question is that this is the thing that I want to to share with all of you. But the question is that, does the fact that the Constitutional Court judges were appointed by the junta really lead to the fact that the rule of law being completely dismantled in Thailand? I would say that the question is no, not at all. The answer is that, of course, some Constitutional Court judges were appointed, although even though some judges were appointed by the junta, this doesn't mean that the rule of law has already died or completely dismantled in Thailand. Instead, we can also, find some decisions, made by the Constitutional Court that appear to improve, the rule of law in Thailand as well. For instance, back in 2020, the court, rendered the decision called the Rajat case. Well, this case, is concerned with the constitutionality of two junta orders, two military orders, issued by the junta back in 2014. Back at the time, as I just point out, there was a military coup. There was a military coup in Thailand, right? And the junta at the time, issued a number of junta orders, summoning people to report to the military official. And one of those who were summoned, to report himself to the junta was Professor Rajat Pakirat. Professor Rajat, is a very famous professor in Thailand. He's widely regarded as a pro-democracy scholar. So that's why he has normally been seen as an enemy to the military and some right-wing supporters, right? And as I just said, Rajat was someone to report himself to the junta. And the thing is that, those summoning orders, says that if you fail to report yourself to the junta, you will be sentenced to imprisonment. But Roger, argue that, these orders were unconstitutional because they retroactively impose a criminal sanction upon him. The thing is that, when the junta, seized power back in 2014, the junta just, issue a military order, a junta order, saying that, some people need to present themselves before the junta, right? But later, a few hours later, it it promulgates orders, saying that, if you failed to comply with our orders, you will be imprisoned. So this is a point that Roger, raised in his case. He says that, the orders, retroactively imposed a criminal sanction upon him. And at first, before the Thai Constitutional Court, adjudicate this case, a lot of scholars, including me, we thought that the court, tend to the court may, side with the junta, but we were wrong because at the end of the day, the court, agree with Voyager and declare the orders unconstitutional. So I would say that I would regard, this decision as good example of how, that of how, the Thai Constitutional Court, can play the role in protecting or supporting the rule of law, despite the fact that most of its judges were appointed by the junta itself. But in cases related to Thainess, it appears that the Thai Constitutional Court, appears to, to play a role, to play the role in, protecting, the hegemony of the monarchy. In this regard, I would like to talk a little bit about, the case called the S112 case, or the Move Forward Party case. But what is S112? I'm pretty sure that many of you already know that, Thailand is notorious for our Last Majesty law. And our Last Majesty law is enshrined in Section 112 of the Criminal Code. And in Thailand, we call Section 112 S112. Okay, so yeah, in Thailand, if you insult the king, you can be imprisoned for up to 15 years. So this means that Last Majesty, can lead to a very draconian punishment. And the problem in Thailand is that, anyone who knows of a violation of Last Majesty can initiate a lawsuit. So this provision, has been exploited by, by ultra right-wing supporters, to replace, pro-democracy movements. Yeah, because as I said, anyone can bring the case, can initiate the case. They can just, go to a police station, file a case before the police, and then the police normally, start the case. So this is very problematic. And also, this offense is also classified as a public offense rather than a compoundable offense. So we can see that, S112 tries to, link, Last Majesty with, the internal security of the kingdom. It means that, if you insult the king, I mean, the rationale of this provision is that if you insult the king, it means that you are posing, threat to national security as well. Yeah. But back in 2021, the then opposition party, the Move Forward Party, made an effort, to revise, this provision. The thing is that, the Mufward Party, was known for its left-wing and pro-democracy stance. So yeah, so this party, was seen as as an enemy to the monarchy by, especially, by the military and the royalist conservative elites. And the thing is that, back at the time, the Mufward Party, sought to change, S112 from a public offense into a compoundable one. It also addressed, the exploitation of the provision by allowing only the Bureau of Royal Households, or just the Bureau of the Royal Household is like and a department that works directly for the king. It only allows, the proposal is that only the Bureau of Royal Household can initiate the litigation instead of anyone can initiate the litigation. But the problem is that the Thai Constitutional Court did not see the Mufward Party's proposal as the effort to promote the rule of law. Instead, the court says that the king is the embodiment of the nation, and the Mufward Party's proposal is seen as the attempt to detach the monarchy from the nation. So in the court's view, the proposal sought to undermine the monarchy, which is the core of national security, and eventually the court declare the proposal unconstitutional. And later in August 2024, last year, the court used this accusation to declare the Mufward Party dissolved. So now this party is already dissolved, no longer exists. But some members of the Mufward Party, they nowadays they form a new party called the People's Party. So in Thailand, you can see that, well, that like Indonesia and Malaysia, there are some some progress on the rule of law, but at the same time, we can also witness decline in the rule of law as well. So now we reach the final part of the presentation, because now I'm trying to draw some conclusion from my presentation. My key question is, should the Southeast Asian context be seen as an example of the rule of law's erosion? I would say that it is too hasty, to conclude that the rule of law has been completely eroded and has died in Southeast Asia. I would say that we can see that, well, several Southeast Asian countries have witnessed both convergence with and divergence from the standard concept of the rule of law. This is pretty normal. I think this trend appears throughout the world, including in Southeast Asia as well. So I would say that it is better to understand the implementation of the rule of law in Southeast Asia, especially in the three countries that I present in my lecture, in terms of a process still in development. This is the thing that I want to emphasize, instead of as a kind of an entrenched and dominant ideology. Yeah, and it remains to be seen, the trajectories of the rule of law development in this region in the future. Yeah. So this is all my presentation, and I think we still have we got plenty of time for Q&A and some discussion. So thank you very much, and I'm really looking forward to listening to hearing your questions. Thank you.
Okay, thank you so much, Dr. Lawin Lilapatana, for the best explanation about this topic. So thank you so much who present about the erosion of rule of law in declining democracies. His presentation very well and informatively. Hopefully what has been conveyed will provide long-term benefits to all of us. Now, it's time for the question and answer session for the audience who are curious or want to discuss further regarding this discussion. Let's make the best use of this opportunity. As a reminder, the question and answer session is divided into sections. In the first session, we'll limit it to 3 questions. When the time is up, there will only be 1 question and answer session. For questions, you can submit them via Zoom. For the question, you can submit them via Zoom live chat, or you can express them directly by activating the raise hand feature, which will be invited by the moderator to open the microphone. For all participants, the screen and time are yours. All right, for the first question from Mr. Abdul Al-Farashi, your time is yours. You can open mic for your question.
All right. Is my voice is clear? Hello. Is my voice clear?
Yes, your voice is clear, and
Oh,
I can
alright.
hear that.
Okay. Sorry Kak Pacan. All right. I mean, I'm based on your explanation, I'm pretty sure that laws should safeguard fundamental human rights, right? But when it comes to this individual right, sometimes we don't know who's the one should we try, since the man-made always never be made as a perfect, or everyone has their own perspective, right? So this will arise to some horizontal conflicts or either vertical conflicts. And how do you address this issue when we still have to ensure the equality and the justice for everyone? How the rule of law can tackling this issue?
Should I answer the question now, or should I wait until we
can
gather
answer
all
now.
the questions? Oh, we can answer. I can answer
Okay.
that. Okay. Thank you very much for the question. I would say that this is a very interesting question, and I think that the rule of law provides parameter for dealing with the conflict between I would say state power and the protection of individual rights. If we look at the international human rights treaties, they normally say that, well, in order for the state to impose restrictions on human rights, the state has to do this on the basis of law, right? And the law should be clear and precise in order to ensure that subjects know the consequences of their actions. And also these treaties also says that, well, in order for the state to to restrict human rights, they need to comply strictly with the principle of proportionality, right? So yeah, so I think perhaps the principle of proportionality might be I mean the answer to this question. I mean in order to ensure that the conflict between state power and different rights be resolved, yeah, the state has to comply with the principle as such. Yeah.
All right. Thank you, Ajan. ขอบคุณครับ
ขอบคุณครับ
Okay, for the next question come from via Zoom chat. For the first question from Mrs. or Mr. Sukmareni Rajab. I want to read this. It's very interesting to know the difference in the rule of law concept present. I want to know what Mr. Rawin thinks about the implementation of the rule of law in Indonesia in the last few years until the emergence of dark Indonesian demonstration in recent days. We think that the law is no longer pro-people. Is it still in the ideal category of implementing the rule of law compared to the implementation in other countries? Okay, thank you.
Thank you very much for the question. I would say, because I'm not an expert in Indonesian law, but in the past 5 years, I had two opportunities to study Indonesian constitutional law, and I'm not sure how to answer this question, but from my perspective, from the external perspective, I would say that Indonesia, like many countries in Southeast Asia, like Thailand, like Malaysia, the country has witnessed both convergence with and divergence from the international concept of the rule of law. I remember that when I first studied the Indonesian constitutional law, I had a chance to study the case of what you call that, or mass or something. It's a kind of emergency decree issued by the previous president, Mr. Jokowi, in order to deal with the Islamic movements. And of course, that emergency decree, appears to contravene the rule of law, and it appears that the constitutional court, tend to how to say, to agree with Jokowi, right? I think this is quite. I would say this may perhaps be the trend in Southeast Asia, that sometimes that the government and the judiciary tend to prioritize the survival of the state over the protection of rights. But at the same time, I can also see a lot of great developments in Southeast in Indonesia, and that is why I always say that Indonesia should be regarded as the most stable democratic countries in Southeast Asia. For instance, you adopted a long list of Bill of Rights in your constitution back in 2000 something, right? In the 3rd or 4th Amendment, right? And so it remains to be seen, what the current president, Mr. Prabowo, what will he lead the country to? Because as I understand, he was the one. I mean, his party was the initiator of the idea of the 5th Amendment that I present in my paper, right?
Okay, thank you so much for Dr. Awin. For the next question from Mr. or Mrs. Nur Firnan. I will read this question. Good morning, Mr. Awin. There is something I want to ask in your experience. What are the key early warning signs that indicate a country is experiencing an erosion of the rule of law? Thank you.
Oh, thank you very much. I think this is a very good, very great question. I would say that I can give some examples using my experience from my own country, from Thailand. I would say that a lot of signs in Thailand that shows that reflects an erosion of the rule of law. For instance, in Thailand, nowadays we have witnessed, the rise of the ultra right-wing movements. These movements, they tend to. I think you also have this trend in Indonesia as well, right? Some people, they start to question the legitimacy of the rule of law. In Thailand as well, there are some people, especially the elites, who are very skeptical about the benefits and values of the rule of law. Some of them tend to think that, well, the rule of law is the product of the West, and they normally think that, well, this idea doesn't really fit, the local tradition. And some of them, even prefer, the country to be ruled by a strong leader, adopting, a strong authoritarian ideology, right? I think this is one of the side that signifies, the erosion of the rule of law. And also we can identify, the side of an erosion of the rule of law through, the not just, the recurrence of military coups, but also, the intermittent abuse of human rights. Yeah. I think this is quite normal in in Southeast Asia, that we can find a widespread abuse of human rights. Yeah, I think I would say I would answer this question this way.
Okay, thank you so much for the answer, Mr. So for the next question, and this is the last question from via Zoom chat. So this last question from Mrs. Rani. Could you tell us more about your opinion about the case of S-112?
Okay, thank you very much.
Okay.
Yeah, the last majesty law, right? Yeah, I think it is, it's quite controversial, to discuss, the legitimacy of S-112 in Thailand, because if you ask, the royalist conservative elites, they would say that, well, this provision complies with the international standards of the rule of law, because if they normally say that if we look at the text of international human rights treaties, like the ICCPR, the ICCPR allows the freedom of expression to be restricted on the ground of national security, and these people would say that, well, the security of the monarchy is vital for Thailand to remain as a kingdom, right? So they would say that, well, we need to allow this freedom to be restricted on the ground of protecting the monarchy. So this is the answer if you can get from the pro-democracy, the pro-monarchy advocates. But if you ask pro-democracy supporters, they would say that, well, this provision has been abused by ultra right-wing supporters in order to replace pro-democracy movements. So if you ask these people, they would say that, well, it is important to establish some legal safeguards to ensure that the abuse no longer occurs, and they would side with the Move Forward Party's proposal. Yeah, in my opinion, I would say that it is true that this provision has been abused, and it is important to make sure that this provision is not turned into a mechanism for the ultra right wing to use as political means to replace pro-democracy movements. Of course, a reform to this provision is still vital. And in fact, if you read the news on the Thai Constitutional Court's decision, in fact, the court itself doesn't close the door for the amendment to this provision. So I think in the future it is still, I mean, it, you know, the Thai government still has to still has to think, you know, about, you know, how to, how to ensure that not just, you know, that this provision is not abused, but they need to also think that, well, they need to prevent, you know, there need to be a mechanism that is established to ensure that not everyone can, you know, file the case before the police. Instead, there need to be someone, you know, who can do this. And, you know, because the court decision just says that, well, it should not be the Bureau of the Royal Household because you know, according to the court it says that, well, this proposal, you know, tends to result in the monarchy being politicized. So if the reform, you know, needs to follow the court's decision, maybe the government might think that there might be a kind of a committee that is established to, you know, to, how to say, to consider whether, you know, the S112 case, you know, should be brought before the criminal court or should be dismissed or rejected, you know, beforehand. Yeah, I think this might be possible reform. Yeah.
Okay, thank you so much for
Thank
the
you.
answer, Mr. Winlila Patana. So, because there are no more questions, then the question and answer session is over. Oh, we have one more one again for the question, Mr. Sorry, this is from Mr. Firtan. So he question about, could you share your insight on which countries are currently making progress in improving the implementation of the rule of law? Additionally, what factor or reasons contribute to this progress?
Wow, thank you very much. I would say that, you know, according to the recent news, I would say that we might consider South Korea as a good example of how you know, the rule of law can be protected. As we know, you know, a couple months ago, you know, the previous president of South Korea, you know, declared martial law in order to, you know, to replace, you know, the opposition party, right? But it appears that, you know, his order was resisted by not just by the opposition party itself, but also by the people as well as some military officials. I think I would say that, you know, the fact that you know, the society, you know, feel the importance of the rule of law is the key factors that enables, you know, the rule of law to function really well in a particular country. In Southeast Asia, in South Korea, you can see that you know, that a large number of people there, you know, they no longer want the country to go back to, you know, to its authoritarian days, right? Instead, you know, people want, you know, the country to remain, you know, to function in a democratic way. So they, you know, went to the streets and protest against the you know, the president. Yeah, so this is a good sign, and yeah, I would say that, yeah, South Korea should be considered as a country that you know, has made good progress in improving the implementation of the rule of law.
Okay, thank you so much for the answer, Dr. Rawin Lila Patana. So, because no more question again, then the question and answer session is over. As the moderator, I would like to express my gratitude for the enthusiasm and attention of all participants, as well as thank you so much to our extraordinary speaker this morning, Dr. Rawin Lila Patana, who explained about the erosion of rule of law in declining democracies in a very interesting and easy to understand.
Thank
Oh,
you very much.
dari Dr. Oh yeah, from Dr. Awin, you can give us closing statement before I'm closing this session.
Okay, so once again, I would like to express my special thanks to UMS for inviting me to, to be part of today's event. And I hope that in the future, I will have other opportunities, to join, this international short course. And yeah, I mean, for us, Southeast Asian citizens, I think, the rule of law is an important, subject for us, right? As I present in my lecture, our countries, can no longer resist, the discourse or the rhetoric of the rule of law. But at the same time, we need to admit that, the development of, the rule of law is still in our countries, are still kind of a process in development, right? So I think it depends on us, the people, just as in Korea, right, that we should, perceive its importance. And I'm pretty sure that, in the future, the rule of law can be, more deeply entrenched in our countries. So thank you.
Okay, thank you to Dr. Awin Patana. So I am Ellen Chelsea-Minandito as the moderator for this morning session. Also apologize profusely if while accompanying the participant, there were still many errors in words and pronunciation. I, as the moderator, have permission to say we regret to inform you that for the next session, Dr. Jeremy will not be able to present today. His session will be rescheduled and the update schedule will be communicated in this group at a later time. So you can check your group WhatsApp. So as a result, there will be only one session for today. Thank you for your understanding. So as the moderator, I want to say thank you so much. Once again, thank you. Wassalamualaikum warahmatullahi wabarakatuh. For Dr. Awindila Patana, you can leave from Zoom chat. Thank you so much for
Thank
today.
you very much once again.